CW 024. On the 27th day of June 2022, the defendant opened its defense. Beatrice Hogan Echo, herein referred to as DW1, testified for the defendant. DW1 identified her statement on oath filed on the 28th day of June 2022 and adopted same as her evidence in support of the defense of the defendants. DW1 thereafter tendered exhibit DW001 to exhibit DW005. After the close of hearing of this suit on the 19th day of January 2026, the matter came up for adoption of final written addresses filed by counsel. Learned counsel for the defendant, Smart Opera, identified and adopted his final written address on the 22nd day of February 2023, and reply on points of law filed on the 16th day of January 2026 as his legal submission in the aid of the case of the defendant, and urged this court to dismiss this suit. Counsel for the claimants, D.W. Wuku, identified and adopted his final written address filed on the 15th day of January 2024 as his legal submission in the aid of the case of the claimants, while urging this court to grant the claim of the claimants. Let me briefly state the case of the claimant. The precis of the facts leading to this suit are that the first claimant is a supplier of labor to Nigerian Ajib Oil Company Limited by virtue of a subsisting contract between them. The second defendant is the managing director of the first claimant, which is an indigenous company in the areas of operation of Nigerian Ajib Oil Company Limited. Due diligence documents dated 17th day of April 2017, 15th day of October 2017, and 23rd day of May 2017 were served on the claimants, in which the claimants were requested to produce some requisite documents on due diligence, the certificate of incorporation, Form CSC2, Form CSC7, names of Forms CSC7, names of shareholders, names of board of directors, names of 2 GRP employers in claimant establishment, audit account report for 2016, current tax clearance for 2016, and evidence of payment of DPR permit for 2017, and those mentioned requirements were made available to the defendant through the Deputy Procurement of Division Manager by a letter dated the 31st day of May 2017. The said letter was sent to the defendant through email, and the defendant acknowledged the receipt of same. The defendant did not at the time the said contract was fully executed place as a condition the provision of either a recruiter's license or a new recruiter's license. Neither was it spelled out from the inception of the contract that the non-provision of either a recruiter's license or a new recruiter's license will operate to determine the contract. However, on the 15th day of June 2017, the defendant served on the claimant a purchase order which stipulates that the possession of a valid recruiter's license is mandatory for all labor contracts to the Nigerian Ajib Oil Company Limited, and further that the failure to provide this on demand may result in termination of contract by giving 15 days prior written notice to the contractor. This requirement brings a lot of surprise to all contractors, including the claimant's hearing. Despite these requirements, the claimant made an urgent effort to comply with the said demand. The recruiter's license, to the knowledge of the defendant, is always issued by the Federal Ministry of Labor and not by the claimants. The claimants, as a matter of urgency, immediately applied for the recruiter's license from the Federal Ministry of Labor, who commenced its preparations at once. And on the 30th day of June 2017, the Federal Ministry of Labor and Employment wrote a letter titled Renewal of Recruiter's License, Junela Integrated Service Limited, to General Manager, District of the Nigerian Ajib Oil Company Limited, indicating that the claimants have supplied for a recruiter's license and that the registration process has started, and that same will be forwarded as soon as it is ready. The State Controller of the Federal Ministry of Labor and Employment urged the Nigerian Ajib Oil Company Limited, the defendant, to give the contractor maximum cooperation to enable and meet the contractual obligations. The contract was issued to the claimant on the 15th day of June 2017. It sprang a world of surprise when on the 28th day of June 2017, the defendant served on the claimants a letter titled Real Labor Contract for 2017 Close Out, in which the defendant stated that they will not exercise the optional period after the 4th day of July 2017. The contract number as stated above. The claimants did not owe 2 months pension remittance in 2016 to a defendant, and yet they used this as a ploy to terminate the labor contract of the claimant. The Federal Ministry of Labor and Employment has concluded the process of production of the recruiter's license and has written to the claimant that the said recruiter's license is ready. The defendant, by virtue of several memorandum of understanding entered into between the claimant's committee and themselves as a matter of routine, do grant contract for the supply of automotive gas and oil to indigenous contractors. The defendant had granted such service contract to several persons, but has clearly not included the claimants for the said purpose. This position is not in line with the established contractual relationships between the claimant and the defendants, especially as the claimant, by virtue of its memorandum and article of association, has the capacity to undertake such contracts. The defendant, on the 19th day of June 2017, wrote a letter to Mr. Tekino Emmanuel Enato, who is one of its staff, stating that the name of the first claimant is being used to execute assorted contracts. As a result of this, A.Y. Akintunde, who is a counsel to the above-mentioned staff, wrote a letter dated 29th day of June 2017 to the claimants to indicate the correct position. The claimant, through its solicitor, D.W. Woku, wrote a reply dated 14th day of July 2017 to the said solicitor's letter stating their positions. The defendant did not exercise its option to renew the contract against the terms stipulated in the contract. It is factual that by the computation of time, even if Saturdays, Sundays, and public holidays are excluded, the number of days from the time of the service of purchase order and the time the said closeout letter was served is not up to 15 days that was stipulated in the purchase order. The defendant's allegation that the claimant has not done pension remittance for 2 months in the year 2016 is not borne out of facts, more so as the claimant has done all pension remittances without any encumbrance. As a result of the aforesaid facts, the claimants briefed its solicitors, D.W. Woku, who wrote 2 legal letters to a defendant dated 18th July 2017 and 9th day of October 2017, demanding that the defendants retraces their steps and allow the claimants to continue a supply of labor contract. The claimants also briefed its solicitors, Allen Hope Jonah Esquire of Appelia and Go law firm, seeking an extension of the said deadline. The said letter is dated 3rd day of July 2017. The defendant, however, after several months, served on him a reply indicating that they will not exercise the option to renew the contract. The defendant's refusal to renew the contract is not justified and, in fact, breaches the terms of the contract in all its facets from inception until it was abruptly brought to an end. The signatures of the General Manager District, Marco Rotondi, is significantly different in the close of letter dated in 2017 and the contract purchase order. Let me briefly state the defense of the defendant. The defendant stated that the first claimant was engaged by the defendant to supply labor staff. Due diligence is a mandatory and compulsory annual requirement for all contractors, which includes the provision of all statutory permits, including the recruiter's license, which the claimant failed to provide. The recruiter's license provided by the claimant was not valid as it had already expired. The claimant, through its email dated November 9, 2016, had made a demand on the claimant to forward the said license on or before close of business on 11th day of November 2016, but the claimant failed to forward the same. The defendant made further demand on the claimant via email dated 14th November 2016, but the claimant still failed to provide the same. The Employment and Wages Department of the Federal Ministry of Labor and Productivity, in its letter dated 21st day of January 2013, wrote to a defendant on the danger of engaging the services of an unlicensed labor contractors. The Federal Ministry of Labor and Productivity, in its letter dated 24th April 2015, wrote to the defendant stating that it is a contravention of the Labor Act, Section 23, 26, and 27, to engage labor contractors not licensed by the Honorable Minister of Labor and Productivity, and to further request henceforth the services of such unlicensed contractors be stopped forthwith until certified to above being sanctioned or prosecuted. The claimant's recruiter's license expired in 2014, and all efforts made by the defendant through meetings, emails, presentation in the defendant's auditorium to all labor contractors to enable the claimant and other contractors to provide the said recruiter's license proof about it. The claimant was issued a final letter of defendant's intention to close out the labor contract. The defendant, as a corporate entity, works within the laid down rules and regulations, which include provision of valid recruiter's license by all labor contractors as required by the Labor Act. The defendant could not have waited for the claimant to forward to the defendant at its own time the required due process documents. It is entitled to exercise its right with regard to the optional term contained in the contract by giving written notice to the contractor. The defendant merely exercised its contractual rights with regard to the above, which merely requires that it should give the claimant a written notice. It opted not to extend the claimant's contract upon expiration of the first phase of the contract, and it is not responsible for the suffering of the claimant merely because it exercised its rights as guaranteed by the contract that governed the relationship between the first claimant and the defendant. Learned counsel for the claimant formulated 3 issues for the determination of this suit in their written address. That is, whether or not the claimant's labor supply contract with the defendant can be terminated or closed out against the terms of contract between the parties. And secondly, whether or not the claimants, owing to the necessities of local conditions relating to the relevant fiscal regulations and host community binding obligations, are entitled to be put in a contractual status of supplier of AGO by making them such suppliers. And thirdly, whether or not the claimants are entitled to be paid general damages for the reasonable foreseeable injury caused to them by the unlawful act of the defendant. Learned counsel for the defendants also nominated 3 issues for determination of this suit, to wit, whether the decision of the defendant not to exercise the optional term constitutes a breach of contract, and secondly, whether the claimants are entitled to be put in a contractual status of supplier of AGO when there was no subsisting contract between the parties, and thirdly, whether the claimants are entitled to the award of general damages of 10 billion naira for refusing to exercise the optional term under the contract it had with the claimant. So I will skip your legal submissions and I will go to the decision part of this judgment. Can you hear me? Can you hear me? Okay. I have carefully read through the pleadings and the evidence vis-a-vis the legal submissions made by parties. The issues nominated by parties are almost the same, but differently worded. I am of the view that the suit can be determined by the following issue for determination. That is, whether the defendant is in breach of contracts between the claimant and the defendant to entitle the claimants to the relief of. First thing first, by virtue of Section 131 sub 1, 132 and 133 of the Evidence Act 2011, he who asserts must prove the fact asserted. This is because the burden of proof in every suit or proceeding lies on the party who will fail if no evidence at all were given on either side. Therefore, whoever desires any court to give judgment as to any legal right or liability, dependent on the existence of facts which he asserts, must prove that those facts exist. That party in this case are the claimants who filed the suit. By the provision of Section 133 of the Evidence Act, the burden of first proving the existence or non-existence of a fact lies on them. It is only where they have adduced sufficient evidence that the burden will now shift to the opposing side. See the case of Asurime against INEC, reported in 2025, 17 NWLR Part 2015 at page 433. Thus, the claimants who make the assertion of the contract between the claimant and the defendant, they have the burden to establish their claim against the defendant. Before proceeding further, on the 30th day of January 2020, CW1 adopted her witness statement on oath, filed along with the originating complaint on the 9th day of April 2018, and a further witness statement on oath, filed on the 26th day of November 2019. On the 17th day of November 2020, CW1 also adopted a further deposition on oath, filed on the 29th day of November 2019. A careful search of the process filed by the claimants in this suit. The claimant filed a complaint along with other processes on the 9th day of April 2018. The claimant also filed a reply to a defendant's statement of defense and a further witness statement on oath on the 28th day of November 2019, and another further witness statement on oath filed on the 11th day of December 2019. Invariably, there is no further witness statement on oath filed on the 26th day of November 2019, and a further deposition on oath filed on the 29th day of November 2019. It then means that there is no evidence in support of the reply filed on the 28th day of November 2019. The reply will be deemed abandoned unless there is evidence from the records which supports the abatement contained in the reply. In the case of Ojo against Kamalu, Toby JSC had this to say, and I quote, "Pleadings, not being human beings, have no mouth to speak in court, and so they speak through witnesses. If witnesses do not narrate them in court, they remain moribund, if not dead at all times and for all times, to the procedural disadvantage of the owner." Unquote. Also relevant is the case of Alao against Akanu, where Akintan JSC, among others, stated this, and I quote, "The law is settled that where issues are joined on any abatement in the pleadings, but no evidence is laid to support such abatement, the result is that such abatements in the pleadings is either to be struck out or be dismissed. In other words, such abatement could be treated as having been abandoned." Unquote. Moving forward, as can be gleaned from the pleadings before me and the relief sought by the claimants, the claim of the claimants against the defendants are in twofold, to wit, contract for supply of labor and contract for the supply of AGO. From the evidence before me, there are three sets of contracts between the claimants and the defendant. Purchase order number 46003179, which is exhibit CW002 and exhibit CW004. And then another purchase order 52000761, which is exhibit CW003. It is strikes that if parties have agreed between themselves upon the condition for the formation of a contract, and these conditions were embodied in a document, then they are bound by the terms and conditions set out in the contract documents. Having so bound themselves, it is only the duty of the court to make a contract for them. It is not the duty of the court to make contract for the parties. See the case of Kaidi Ventures Limited against Minister of FCT. In the case of Akinola against Lafarge Africa PLC, reported in 2022, 12 NWLR Part 1844, page 379, at page 410, paragraphs A to B, where the Supreme Court held, and I quote, "It is settled law that where parties enter into a contract, they are bound by the terms thereof, and the court will not allow to be read into such contract terms on which there is no agreement." Unquote. Exhibit CW001 triggered the claim of the breach of contract by the claimants against the defendant. Exhibit CW001 reads, and I quote, "Re-label contract for year 2017 closeout. Reference is made to the contract with the underlisted number signed with their company for the provision of the personnel for Nigerian Ajib Oil Company JC operations, number 46003179. Furthermore, taking into consideration the following facts, that contractor has not done pension remittance for 2 months in the year 2016, has failed to submit renewed recruiter's license, which expired in November 2014 as requested by Nigerian Ajib Oil Company. Consequent to Article 2.1 and 2.4 of the contract and relevant provisions in the general conditions of contracts, please be informed that Nigerian Ajib Oil Company will not be exercising the optional extension period Optional term, after 4th day of July 2017, fixed period. Please acknowledge the receipt of this letter as provided below. Unquote. In view of the content of Exhibit CW001, the contract between the parties, which was terminated by Exhibit CW001, is Exhibit CW002, CW004. Notwithstanding the foregoing, CW002 and CW004 is an appendage to Exhibit CW003, in that Exhibit CW003 is a general contract, while Exhibit CW002, CW004 is a specific contract for support service for labor. In enforcing or interpreting Exhibit CW002 and CW004, Exhibit CW003 must be read along with Exhibit CW002 and 4. The recital part of Exhibit CW003 provides, and I quote, company hereby requests and authorize the contractor to provide specified and described below service. Said service shall be performed in accordance with and shall be governed by the terms, conditions, and prices contained in the Framework Agreement number 520000761, dated 1st June 2017, carried on after called the framework executed between the company and the contract. Unquote. This recital indicates that the terms and conditions contained in Exhibit CW003 form part of Exhibit CW002 and Exhibit CW004. The closing paragraph of Exhibit CW002 and 4 provides, and I quote, all other terms and conditions not in conflict with the above and with the current bargaining agreement shall be as per the framework and the company's general condition. Unquote. This implies that any other terms and conditions that do not contradict Exhibit CW002 and 4's provision and align with the existing bargaining agreement shall adhere to the framework and the company's general condition. In essence, the terms and conditions in Exhibit CW002 and 4 are for a specific purpose, while the terms and conditions in Exhibit CW003 are for general purpose. Page 2 of Exhibit CW003 even states, and I quote, company will from time to time award contractor specific service orders instructing contractor on the required services based on the specific terms described in the service orders, while the general terms can be governed by this FWA, unquote. In construing the relationship between employee and employer under a contract, the court must confine itself to the plain words and meanings to be derived from the written contract. And interpreting the provision of such a written contract, no addition thereto or subtraction therefrom is permissible. The words used must be given effect to, and no word should be ignored in the interpretation of the intention of the parties. Accordingly, the court does not have the power to look elsewhere for the terms of contract with regard to the termination of a contract other than in the written agreement. See the case of Momo against CBN. In this instant case, the terms and conditions in Exhibit CW002 and CW004 form part of Exhibit CW003 and the defendant's general conditions. I have taken cognizance of the submission of the learned counsel for the claimants. In paragraph 5.9 of his final written address, counsel cast aspersion on Exhibit CW002 and CW004, where counsel argued that the specimen of service order contained in Appendix C of Exhibit CW003 is not the same as Exhibit CW002 and CW004. I am in a rude shock with this submission, as this submission was not founded in the pleadings and evidence before me. No matter how beautiful a counsel written address is, it cannot take the place of evidence. A court is bound by the evidence before it and not the address of counsel, not supported by material evidence. In the case of UB against Oxibo, reported in 2022, 10 NWLR Part 1839, 341 at page 461, paragraphs E to C, the Supreme Court held, and I quote, the law is right that counsel cannot use his address to the court to introduce evidence which was not adduced by parties during trial. Such evidence in counsel's address shall not be used for the resolution of issue in the appeal, even where such evidence was available but not adduced at the trial of the suit. Counsel does not have the province or latitude to introduce it by any stretch of ingenuity in his address. Unquote. Even if this was part of the case of the claimants during the trial, I do not think it is ethical for the claimants to challenge the legality of exhibits CW002 and CW004, having benefited from the same agreement. It is morally despicable for a person who has benefited from an agreement to turn around and state that the agreement is null and void. This is in pursuance of the principle that law should serve public interest. And in that regard, the courts have evolved the technique of construction in bonum patem. One of the principles evolved from such construction is that no one should be allowed to benefit from his honor. Nullus omodum capera partes de injuria sua propria. In BB Apugo Limited against OHMB, the Supreme Court held that it is unconscionable for a party who voluntarily entered into contract and has benefited under the contract to seek to avoid his obligation under the contract on the ground that the contract is void, unless ex facie the contract is illegal, where the principle of ex topi causa non orito actio applies. Now, on the breach of exhibit CW002 and CW004, the reason the defendant gave for the termination of exhibit CW002 and 4 is that the claimants had not made the remittance for 2 months in 2016 and failure to submit a renewed recruiter's license, which expired in November 2014, as requested by the defendant. Paragraphs 4.1 and 4.2 of exhibit CW003 provides, and I quote, paragraph 4.1 stated, payment due to contractors shall be effected within 30 days from the date of submission of invoices to the Finance and Account Department of the company. 4.2 provides, notwithstanding clause 4.1 above, contractor shall pay contractor personnel all allowances and salary at the end of each calendar month without financial recourse to the company. Paragraph 2.4 of exhibit CW002 and 4 provides, and I quote, company reserve the right to terminate the contract at any time in the event of a report of late payment and or non-payment of salaries or allowances, as well as pension remittance to the contract's personnel indicated in this contract by giving 15 days prior written notice to the contractor. Unquote. A combined digest of the provisions from exhibit CW002 and 4 and exhibit CW003 reproduced above shows that timely payment of salary, allowances, pension, remittance is sacrosanct to the sustenance of the contract between the claimants and the defendant. On the issue of failure to remit the pension for 2 months in 2016, the claimants pleaded and led evidence to state that the claimant did not owe 2 months remittance in 2016. CW2, who is a representative of the Pension Alliance Limited, gave evidence before this court to the effect that the claimants were not in default of pension remittance in 2016 and even tendered exhibit CW0023 and CW0024. The defendant raised the issue of non-remittance of 2 months pension in 2016 via the exhibit CW001 dated the 20th day of June 2017. Exhibit CW003 shows that the claimant remitted the pension of their personnel for January to June 2016 in 2016. This is evidenced by the deposit slip of UBA stamped on the 15th day of June 2016. Another remittance of July 2016 was made in 2016, and it is evidenced by UBA deposit slip stamped on the 3rd day of August 2016. Another remittance of August 2016 was made in 2016, and it is evidenced by UBA deposit slip stamped on the 21st day of September 2016. Another remittance of September and October 2016 was made in 2016, and it is evidenced by UBA deposit slip stamped on the 13th day of December 2016. And another remittance of November and December 2016 was made in 2017, and it is evidenced by UBA deposit slip stamped on the 10th day of January 2017. Where documentary evidence supports oral evidence, such oral evidence becomes more credible. This is premised on the position of the law that documentary evidence serves as a hanger from which to access oral testimony. See the case of BSc Electrical Company Limited against Additional. Though there were delays in the remittance of pension, but at the time the defendant issued Exhibit CW001, there was no outstanding remittance as claimed by the defendant. And the defendant alleged no remittance of 2 months pension, not a delayed remittance. I hold and find that terminating the contract between the claimant and the defendant for non-remittance breaches the contract between the claimant and the defendant. Worse still, the defendant did not lead evidence to prove its allegation of non-remittance of the 2 months pension of 2016. On the second reason given by the defendant, failure to submit a renewed recruiter's license, which expired in November 2014. The claimants pleaded and led evidence to state that the defendant did not, at the time the said contract was fully executed, place as a condition the provision of either a recruiter's license or renewed recruiter's license. Neither was it spelled out from the inception of the contract that the non-provision of either a recruiter's license or a renewed recruiter's license will operate to determine the contract. However, on the 15th day of June 2017, the defendant served on the claimant a purchase order number 4600031739, which stipulates that the possession of a valid recruiter license is mandatory for all labor contractors to the Nigerian Ajib Oil Company Limited, and further, that the failure to provide this on demand may result in termination of the contract by giving 15 days prior written notice to the contractor. These requirements bring a lot of surprise to all contractors, including the claimant hearing. The fifth recital of Exhibit CW003 provides that the claimant shall have a recruiter's license. Furthermore, Exhibit CW002 and 4 provides, and I quote, possession of valid recruiter's license is mandatory for all labor contractors to the Nigerian Ajib Oil Company. Failure to provide on demand may result in termination of the contract by giving 15 days prior written notice to the contractor. Unquote. Both Exhibit CW002, CW004, and CW003 provides for the recruitment of a recruiter's license. And at the time the defendant terminated the contract in Exhibit CW002 and 4 via the Exhibit CW001, the claimants did not have a valid recruited license as required by Exhibit CW004, 2, and 3. I do not think the defendant can be accused of breach of terms of contract in Exhibit CW002, 4, and 3, since the claimants did not have a recruiter's license as required by Exhibit CW002, 4, and 3. Although there is an avalanche of evidence before me that the claimants had started the process of getting a recruiter's license, this can be inferred from Exhibit CW018, CW019, and CW020. But I do not think the defendant can be faulted for exercising its right of option not to extend the contractual period. In fact, not having a valid recruiter license as required by Exhibit CW002, 3, and 4 is a breach of contract by the claimants. I therefore hold that the claimants failed to prove that the defendant breached the terms contained in Exhibit CW002, 3, and 4, having failed to provide the recruiter's license as required by Exhibit CW002, 3, and 4, and I so hold. Counsel for the claimant argued in paragraph 5.2 of his final written address that Exhibit CW001 was served on the claimant on the 28th day of June 2015, that counting from 28th day of June 2017, that counting from 28th day of June 2017 to 4th day of July 2017, the number of days is less than 15 days. As it can be seen on Exhibit CW001, the claimant was served on 28th day of June 2017. I agreed with the claimants that the claimants were served with Exhibit CW001 on 28th day of June 2017, which conveyed the intention of the defendant not to grant an extension of contractual period. The first phase of contract expired on the 30th day of June 2017. Paragraph 3 of Exhibit CW002 and 4 provides for 15 days prior notice to the contractor. The defendant breaches paragraph 3 of Exhibit CW002 and 4, having failed to give 15 days written notice as required, and I so hold. The claimants further pleaded and led evidence to state that the defendant, by virtue of several memorandum of understanding entered into between the claimants community and themselves, as a matter of routine, do grant contract for the supply of automatic gas and oil to indigenous contractors. The defendant had granted such a service contract to several persons, but has clearly not included the claimants for the said purpose. This position is not aligned with the established contractual relationship between the claimants and the defendant, especially as the claimants, by virtue of their memorandum or article of association, has the capacity to undertake such contract. In Shell Petrol Development Company Limited against Umaka, the Supreme Court held that a party whose claim is based on contractual rights should plead the contract, the term which gave the right, what created the obligation, and what constituted breach. In the instant case, the snag in the claim of the claimants here is that such agreement or memorandum of understanding between the claimants and the defendants for a supply of automatic gas oil is not before this court. I wonder how the claimants expect the court to resolve their claim on the supply of automatic gas and oil, where the basis for the claim is not before the court. Thus, the claimant failed to prove the existence of such memorandum. Flowing from the foregoing, the loan issue for determination is partly resolved in favor of the claimant, having proved his case on preponderance of evidence. In view of that, relief B is granted, while reliefs A, C, D, E, and G are refused accordingly. And I award the sum of 2 million naira as damages in respect of relief B, which was granted by this court. All terms of this judgment are to be complied with within 30 days from today, and judgment is hereby entered accordingly.
We have had the judgment of the court, the celebrated one, and we always learn at the bottom of the court. Thank you, my lord. Thank you, my lord.
Yes.
Thank you.
My lord, we thank my lord for the considered judgment. Great.
Yes, we have a second matter, Kaikoba Nigeria Limited, for continuation of hearing.
Yes, my lord.
Yes,
we,
my
have,
lord.
We have filed the additional witness statement on it, together with the additional list of documents. We have sent it to the email of counsel, but I'm sorry, I have not yet seen it. So sorry about that, my lord. We have filed the additional witness statement on all of the. Yes, my lord.
My lord, we've not been clear with that process, and even the email he's talking about, we have not gotten any email in that respect. So, to that extent, my lord, we don't even have a copy of his witness statements or any of the documents that he intends to rely on.
My lord, we'll apply most successfully for. Yes, my lord. We'll take a date to do that, my lord. Thank you, my lord.
Give us a date.
As the court pleases.
May we be guided by the court registrar.
May we be guided, my lord.
You said third or what? 3rd June. Is 3rd June convenient to both of you?
4th of June?
Yes.
My lord, the 3rd of June is convenient.
My lord, the 3rd of June is also convenient for the claimant. We'll be here to conclude our case, my lord. 3rd of June is convenient.
By 12 p.m.
12 p.m., my lord. Yes, my lord.
As court pleases.
As the court pleases.
So this matter is adjourned to the 3rd day of June 2026 with the consent of both parties for continuation of trial by 12 p.m.
As the court pleases. Thank you.
Yes.
English figure. Have are they offer for? Yes, no. Say, yes, granted.